All right, welcome in everyone. Welcome to the Burr Morning Show. I'm Carlton Hilson, and I'm joined by Gabriell Jeffries. I know this format is a little different than we originally proposed. It's actually Wednesday, March 22nd, and not Friday. But appreciate everybody joining us. And we're going to talk this morning about an issue we've gotten a number of questions from clients on, and that is the Federal Trade Commission's proposal to ban virtually all non-competition agreements nationwide. It's just a proposed rule at this time, but it's something that we've certainly been questioned about a lot, and there's a lot of uncertainty surrounding it and how to deal with it should it go into effect. So we thought it'd be a good topic for today's morning show. So Gabriell, why don't you tell us a little bit about how this came about?
Yeah, so this goes back to July of 2021, actually, when President Biden issued an executive order on promoting competition in the American economy. And he issued this order to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. And this order came after a campaign promise by President Biden to eliminate all non-compete agreements. And he called on several federal agencies to take action on promoting competition. This FTC proposed rule is probably the biggest action on that we have seen so far.
Yeah, and like you mentioned, it's something that Biden discussed during his campaign, but it's obviously taken several years for it to actually become a proposed rule, at least at this stage. It's something that I almost want to say was forgotten about by a lot of people. Certainly, it was not on my radar until it popped up in January. But the idea that non-competition agreements would be banned is not, totally foreign. In fact, I think 3 states have already had bans in place, and the District of Columbia as well. And then 11 other states have pretty strict limitations on who an employer can place a non-compete on in terms of their salary level. So things have kind of been trending this way, at least at the state level. So for the federal government to focus in on it is not a total surprise. So Gabriell, tell us where we are in this rulemaking phase at this stage.
So like we said, this rule came 18 months after the president's executive order. And where we are is that the FTC recently hosted an online public forum to examine its proposed rule on February 16th, and then extended a comment period for this rule. So we're currently in the comment period, which does not close until April 19th.
Yeah, and it's my understanding that the rule has received a tremendous number of comments, mostly critical of the proposed rule. A lot of comments from pro-business groups, as you could imagine, and last I heard, there was over 1,000 comments to it, which is a lot for a proposed rule from the FTC or any federal agency. So it's definitely gotten a lot of attention, and people know, hey, if this went into effect the way they're proposing, it would really cause a lot of issues in virtually all sectors of the economy.
And one of the reasons with that is how broad this rule actually applies. So for instance, the proposed rule defines worker very broadly. So it is defined as any natural person who works, whether paid or unpaid, for an employer. So this doesn't just include employees. It also applies to independent contractors, externs, interns, volunteers, apprentices, or even sole proprietors who provide a service to a client or customer.
Yeah, and so what I really read from that is it would ban non-competes on all employees, regardless of your job position, your job duties, how much money you make. So we're talking even a president of a company. An employer could not have a non-compete with the president of the company or their chief sales employee. No matter what the position is, no matter how important, no matter what the duties are, it's a total ban of non-compete.
And so now that we've gone through just a little bit of the background, you're probably wondering what exactly this proposed rule would do. So just a few of the major points that we've gotten from the proposed rule. The main point is that it would prohibit an employer from entering into or attempting to enter into a non-compete clause with a worker. In addition to that, it would also require businesses to rescind existing non-compete clauses. So this is not just a prospective rule. It also requires employers to rescind existing non-competes and provide notice to the employees of this.
Yeah, and one of the things I'll add about that, Gabrielle, is the notice provision. It has to be individualized notice. So if every employer that has non-competes, both with current employees and former employees where that non-compete is still in effect, you actually have to contact them by letter, email, text message, whatever it is, individually, and tell them, hey, remember the non-compete we had you sign way back when? It's no longer effective. You're free to go do as you wish, which is a big part of it.
Yeah, so it's extremely far-reaching, and it's not only applicable to just what we would traditionally think of as non-competes. It can also reach some other contractual provisions, such as training repayment agreements, which would require a worker to repay training costs upon separation. And also possibly puts at risk non-disclosure agreements that protect confidential information, because if they're drafted extremely broadly, they could essentially prevent a worker from seeking or accepting employment with a person or operating a business after the conclusion of their employment with the employer who they have the agreement with.
Yeah, and I mean, non-disclosure and confidentiality agreements are expressly identified in this proposed rule as something that would be scrutinized, and the traditional non-disclosure confidentiality agreement that's drafted as broadly as possible by employers to try to encompass and protect any and all information that exists now or could exist anytime in the future is going to be viewed as a de facto non-competition agreement that's going to run afoul of this rule, should it go into effect.
And so we've talked about what this rule covers. And so you're probably wondering, are there any exceptions? Well, there are, but they are extremely limited. So the first exception in the proposed rule, and it's actually the only one that is written into the rule, is a limited exclusion for non-compete clauses between the seller and buyer of a business. And even this exception itself is very narrow, because for it to apply, the person selling the business must have at least a 25% ownership interest. And then also there are exclusions just from the industries that are exempted from coverage under the FTC Act. And this includes banks, savings and loan institutions, federal credit unions, common carriers, air carriers, foreign air carriers, and individuals and businesses subject to the Packers and Stockyards Act.
And the big one there, Gabrielle, is obviously banks wouldn't be subject to this. And we all know that it's common in the banking industry to have non-competition agreement, especially for loan officers and people in sales positions. See those all the time. So this would not impact traditional banks. However, the flip side of that is all other businesses and all other sectors of our economy would be covered by this.
Yes, so if you don't fit into one of these specific exclusions, it would apply to your business. So next we want to go over what happens now. Well, right now we really are just waiting. Like we said, it's during the comment period, but there are some things that employers can do to prepare. So probably the most immediate of that is to monitor the rulemaking process. You want to make sure you're up to date for if and when this goes into effect. So, but things that you can be doing in the meantime is reviewing existing agreements to determine whether they'd be subject to the rule, being prepared to revise those agreements if you think they may be, and then also being prepared for the possibility that you may have to rescind existing agreements with non-compete provisions if this rule does take effect.
Yeah, and And what I would say on that is we can't predict right now when the rule might actually go into effect. But as we mentioned earlier, the notice and comment period is expected to close or scheduled to close on April 19th. And from there, there's a whole lot of comments the FTC is going to be reviewing and considering. There'll be more discussion about this. But I would be looking for something towards the end of the year. And, a final rule will be published. And then there will probably be a compliance period. It might be 90 days. It might be 120 days, whatever it is, before the rule from publication actually goes into effect. But one of the things I think would be important to do, considering how this is currently proposed, is just to work on a list of who actually has non-competes in your business, current and former employees, so we can be ready to address those should some version of this go into effect, which we certainly expect.
Yeah, and then a few other things that you can do to prepare for this is continue to draft your restrictive covenants very narrowly as possible, really, to protect legitimate business interests. And also remember to include language in there that if anything is found unlawful in the agreements, that those provisions specifically can be severed. And then another thing,
or revised is what I would add to that too. Not just severed, but if something runs afoul of current law, that it can be blue penciled or revised.
Yes. And then also just generally keep in mind that restrictive covenants in general should not be used with lower level workers absent legitimate reasons to do so. And then finally,
okay. Go ahead, Gabriell.
You'll want to consider the potential for other agreements to be used to protect proprietary information and client relationships without running afoul of the new rule. So this is where we brainstorm other ideas for how you can still protect your information, but not run into potential problems when this rule goes into effect.
Yeah, and the key that jumps out to me is, this rule does not ban all confidentiality and non-disclosure agreements. What it would do is ban overly broad confidentiality and non-disclosure agreements. So whether now or when the final rule comes out, we're going to be looking to take a look at any and all confidentiality non-disclosure agreements and more narrowly tailor them. And when in the past we've wanted to draft them as broadly as possible to protect as much company information, everyone's going to need to take a look at, hey, what type of data, what type of information do we really hear, what do we actually consider confidential and proprietary that were really harmful to our business if it became public or a competitor got its hands on our information, and kind of tailor the confidentiality agreement to protect that and only that, so it can't be construed as being overbroad. And then I would think, as this moves forward, we're going to be, because that type of information is always evolving and changing in any business, these types of confidentiality agreements are going to be we're going to need to review them on an annual basis, I would think, maybe an annual or biannual basis to make sure they're still up to date, they're not overbroad, there's no category of information we need to delete from them or add to them.
Yeah, so obviously this rule, just the proposed rule, has caused a lot of waves, and we've been receiving a lot of questions about this rule. So Carlton, would you like to share just some examples of the kind of questions that we're seeing from clients?
Yeah, so, and we might have touched on this a little bit earlier, but how would the rule impact existing non-competes? So for example, it seems like this rule is going to ban non-competes moving forward, but what about employees that already have non-competes?
Yeah, so we did touch on this a little bit earlier, but it's very important to know that this is not just about any future non-competes that you may enter into. this rule in its current form would also require you to rescind existing non-competes you have with employees or former employees. And not only does it just require you to rescind them, but it also requires you to send out that individualized notice that we talked about earlier. So that would be pretty drastic action that it would require on the part of employers.
Another one we've certainly received comments on are like, what are the damages if we are in violation of this? Do we know?
So the notice of proposed rulemaking itself did not specifically identify any damages for this. Generally, we know from the FTC Act that there is no private cause of action for this. So individuals are not going to be suing you under this rule specifically, but the FTC does have its own enforcement mechanisms, and it does have the ability to levy civil penalties.
Yeah, and I would anticipate, Gabrielle, that regardless of whether there's a private right of action under the FTC's rules and regulations, there are going to be some creative plaintiffs' attorneys that use this to come up with new causes of action that I can't think of as we sit here right now, but there will be some brainstorming sessions on how to claim fraud or something along those lines for employers who just continue to use non-competes, threaten to enforce non-competes or whatever it may be against current and former. Gabrielle, this is a proposed rule right now. We don't know what is going to happen for certain, but how would you handicap the odds that this goes into effect?
Well, the odds of this going into effect in its current form are probably very low. As Carlton mentioned earlier, there have been thousands and thousands of comments submitted on this already. So one thing that tells us is that the FTC will probably take those comments into account and tweak this rule at least a little bit before a final rule even comes out. But even once we get a final rule, we're anticipating a lot of legal challenges to the rule. So the odds of something happening, of us getting a rule on non-competes, is very likely, but of it being the exact form the notice of proposed rulemaking is giving us seems unlikely.
Yeah, and I mentioned at the start of this that there's already a number of states that either outright ban non-competes totally or at least partially right now. And what I can see happening is when this final rule is issued, yes, there's going to be legal challenges at the federal level, but in the meantime, more and more states are going to become more restrictive on their non-competes as well.
Yeah.
So I foresee a lot of state level action should there be the legal challenges to the federal rule that we certainly anticipate.
Yeah, and we've already seen, as he said, some states that have put non-compete laws into effect, and they have various exceptions and solutions to this. For instance, some states have a minimum wage level under which non-competes are completely banned, and then there are others that exempt certain positions or if they're over that wage level. So we could see different exceptions like that also being implemented into this federal rule.
What about an employer who says, okay, I want to provide some additional compensation or consideration to employees who will, agree to a non-compete with me? So in other words, I'm not going to force anyone to sign one, but I'm going to offer, hey, this is important to us. We'll give you additional money if you'll agree to a non-compete. Would that be permissible under this proposed rule?
Under the proposed rule, that would not be permissible. It is pretty much a categorical ban. So even if you were offering additional compensation under the proposed rule, that would not be permissible.
Yeah, and that, again, can't predict what's going to happen, but that is one of the things that I can see the FTC considering, maybe some salary thresholds that, okay, we're not going to enter a total and complete ban on non-competes, but we are going to ban them under a certain salary level, or only allow them if the employer will agree to provide some type of consideration over and above what it pays other employees in similar job positions. Something like that I can see actually going into effect. And then, another thing I wanted to just mention is we've seen, or the FTC has said that this proposed rule would actually affect 1 in 5 workers in America, or about 30 million people in its proposed form. So I mean, this would have far-reaching consequences. And then finally, Gabrielle, why don't you just, we've certainly gotten a lot of questions about if non-competes are banned, what can we do to protect our data and information? That's obviously unclear right now until we get a final rule, but Gabrielle, why don't you just kind of reiterate what some of those strategies would probably be?
Well, some of those strategies would be you're putting in place confidentiality or non-disclosure agreements. And, you want to watch out for what we talked about earlier, is that those being so broad that they become de facto non-competes. So what's going to be key there is actually looking into specifically what kind of information you are looking to protect, what it is that you would not want going to a competitor, and try to be as specific as possible and narrowly tailor these agreements to address the specific information and that you are trying to protect, so that they have the best chance of, holding up.
Yeah, and I'm thinking, instead of using those broad, vague terms we've all seen in confidentiality agreements, like employee agrees not to disclose all marketing plans and data, and just kind of big, broad phrases like that, we're going to need to specifically describe, like, will not disclose the algorithm on this, the formula on this product, the manufacturing process for this machinery, whatever it may be, but just really drill down and be specific. And that's going to be time consuming, both for us and all companies and employers to do brainstorm, make decisions on what we actually want to include in here, and can we really enforce this agreement, or is it going to run afoul of this law? So yeah, those are some of the main questions that we've received to date. I know when the final rule comes out, there's going to be a whole host of new issues and new questions for everybody to work through together, but we'll just have to wait and see on those. So, Gabrielle, I appreciate it. If anyone has questions about this or wants to talk about it now, please feel free. There's our contact information you can see on the screen. Please feel free to contact me or Gabrielle, and we'll be glad to assist you. Thank you.
Thanks, everyone.